Hi everyone. In the previous video, we have discussed about intellectual property, the rights, the types of intellectual property. Today, we are going to discuss about Indian Patent Act 1970, its recent amendments and the protection of new GMOs, that is genetically modified organisms. Indian Patent Act 1970, along with the Patent Rule 1972, came into force on 20th April 1972, replacing the Indian Patent and Design Act 1911. After India became a signatory to the TRIPS agreement, for the purpose of reduction of distortions and impediments to international trade and promotion of effective and adequate protection of the intellectual property rights, the Patent Act 1970 has been amended in the year 1995, 1999, 2002 and 2005 to meet its obligation under the TRIPS agreement. So, in order to fulfill its obligation and to meet up the international standard, necessary modifications has been done in the Indian Act 1970, and that is what we know as amendment or the modification, and it has done in 1995, 99, 2002 and 2005 respectively. The Act has been amended keeping in view the development of technological capabilities in India, coupled with the need for integrating the intellectual property system with international practices and international property regimes. The amendments were also aimed at making the Act a modern, harmonized and user-friendly legislation to adequately protect national and public interests while simultaneously meeting India's international obligations under the TRIPS agreement. So, the rules under the Patent Act has also been amended and these became effective from May 2003. The rules have been further amended by Patent Amendment Rule 2005 with effect from 1st January 2005. Thus, the Patent Amendment Act 2005 is now fully in force and operative. The Patent Act 1970 remained in force for about 24 years without any change till December 1994. Being a landmark in the industrial development of India, the basic philosophy of the Act or the main objective of the Act include to encourage innovation and eventually result in technological development, to secure that these inventions are worked on a commercial scale without undue delay, it provides a correct demarcation of the patentable and non-patentable substance. So, as we discussed in the previous video about patentable or non-patentable substance, I already mentioned that this rule defines what are patentable subjects and what not are the non-patentable subjects. Thus, the Patent Act 1970 was expected to provide a reasonable balance between the advocate and effective protection of patent on one hand and the technological development, public interest and specific need of the country on the other hand. So, both the benefit of the public as well as the benefit of the creators are protected through this act. And the said philosophy is implemented through compulsory licensing and registration, and we have already come across the intellectual properties, the patents, but I already mentioned that the vital products of our economy like agriculture, horticulture, and atomic energies, they are not considered as patentable subjects. So, a correct demarcation is given. Now, let us discuss about the amendments of the Indian Patent Act. After the Uruguay round of GATT negotiation, the World Trade Organization established. As India became a signatory, it has some contractual obligation to amend its Patent Act in compliance with the provisions of TRIPS. India has to meet the first set of requirements on 1st January 1995. So, necessary modification must be made on the Indian Act. An ordinance affecting certain change in the Act was issued on 31st December 1994. But unfortunately, it ceased to operate after 6 months. So, another ordinance was issued in 1999. This ordinance was subsequently replaced by the Patent Amended Act 1999 that was brought into force retrospectively from 1st January 1995. The amended act provided for filing of applications for product patents in the area of drugs, pharmaceuticals and agrochemicals, though such patents were not allowed. So, in this particular amendment, there were some explanations about how to file an application for the patent of this type of areas like drugs, pharmaceuticals and agrochemicals, etc. But such matters were considered as non-patentable. Even though they were considered as non-patentable, there are some detailing about all these things. However, such applications were to be examined only after 31st December 2004. So, even in the 1999, there were in that particular amendment, there was detailing about that particular sections. It was only examined after 31st December 2004. But meanwhile, the applicants could be allowed exclusive marketing rights to sell or distribute these products in India, subject to fulfillment of certain conditions. India amended its Patent Act again in 2002 through the Patent Amendment Act 2002. So here the specialities were the increase in term of patent to 20 years for all technology, a reversal of the burden of proof and compulsory license, etc. And this act came into force on 20th May 2003 with the introduction of the new patent rules 2003 by replacing the earlier patent rule 1972. So an entire change is brought to the patent rule 1972 and the new and the amended one is established, that is the Patent Act 2000, Amended Act 2003. And the third amendment to the Patent Act 1970 was introduced through the Patent Amendment Ordinance 2004 with effect from 1st January 2005, incorporating provisions for granting product patent in all fields of technology, including chemicals, food, drugs, agrochemicals, etc. This ordinance was later replaced by the Patent Amendment Act 2005 on 4th April 2005, which is in force now, having effect from 1st January 2005. So, in the latest amendment, it detailedly explains about the rules and regulations and for the patent and the patentable and non-patentable subjects, etc. So, the Patent Act, the Patent Amended Act 2005 is the one that is effective now. In the Patent Act 1970, there is a particular section that is for the patent rules. So let's have a look what are patent rules. Under the provision of the section 159 of the Patent Act 1970, the central government is empowered to make rules for implementing the Act and regulating patent administration. These are known as the patent rules, that is the rules that is set by the central government for implementing and regulating the patent administration. The Patent Rule 1972 were notified and brought into force with effect from 20th April 1972. These rules were amended from time to time till 20th May 2003 when new Patent Rules 2003 were brought into force by replacing the 1972 rules. So these rules were further amended by the Patent Amendment Rules 2005 and the Patent Amendment Rule 2006. So the last amendment are made effective from 5th May 2006. While discussing about the amendment, we should also consider the four schedules to the Patent Amendment Rule 2005. The first schedule prescribes the fees to be paid for a particular patent, and the second schedule specifies the list of forms and texts of various forms required in connection with various activities under the Patent Acts. So what all certificates or forms that is to be fulfilled and to be submitted along with this, and these forms are to be used whenever required, and if needed they can be modified with the consent of the controller. And the third schedule prescribes form of patent to be issued on grant of patent, and the fourth schedule prescribes costs to be awarded in various proceedings before the counselor under the act. So far, we have discussed about the Indian Patent Act, its latest amendments. Now we are going to discuss about protection of new genetically modified organisms. In India, the genetically modified organisms and the products are regulated under the rule for the manufacture, use, import, export and storage of hazardous microorganisms, genetically engineered organisms or CELF 1989. So this is a long name, so we can refer to as Rule 1989. It is notified under the Environment Protection Act 1986. And these rules are implemented by the Ministry of Environment, Forest and Climate Change, Department of Biotechnology and state governments with 6 other competent authorities. The Rules 1989 are supported by a series of guidelines on contained research, biologics, confined field trials, food safety assessment, environmental risk assessment, etc. So, by the combined effect of all these, the protection of new genetically modified organisms are carried out. It is not merely protecting the new genetically modified organisms, it also has some guidelines regarding their synthesis, their usage and their distribution among the public, etc. So, Rules 1989 are implemented by MOEFCC jointly with the Department of Biotechnology, Ministry of Science and Technology and state government. So, the 6 competent authorities and their composition have been notified under this rule include the RDNA Advisory Committee, that is known as the RDAC, the Institutional Biosafety Committee, that is the IBSC, Review Committee on Genetic Manipulation RCGM, Genetic Engineering Appraisal Committee GEAC, State Biotechnology Coordination Committee SBCC and the District Level Committee, that is the DLC. So, while the RDAC is advisory in function, the IBSC, RCGM and GEAC are responsible for regulating functions. SPCC and DLC are for monitoring purposes. So, the RDAC is advisory in function that gives the necessary instructions, and the IBSC, RCGM and GEAC are responsible for regulating the function. They are continuously monitoring the functions of a genetically modified organism synthesis or the experiments or invention that include these organisms, and the SPCC and DLC are also for the monitoring purposes. So they just monitor, and these 3 actually regulate. They have some interference within that experiment, and RDSC is the advisory in function. So the Rules 1989 describes the rules and regulations regarding the GMOs. So any illegal activity is or violations is punishable under the Environment Protection Act 1986. The approvals and prohibition under the Rules 1989 are summarized here. No person shall import, export, transport, manufacture, process, use or sell any genetically modified organisms, substances or cell except with the approval of GEAC. So initially I mentioned that GEAC is Genetic Engineering Appraisal Committee, and they have the they are regulatory in function. So without the approval of GEAC, no person have the right to import or export or transport or manufacture. Simply saying, no one can deal with genetically modified organisms or substance or cell without the approval of GEAC. And the second one, use of pathogenic organisms or genetically modified organisms or cell for research purpose shall only be allowed in laboratories or inside laboratory areas notified for this purpose under the Environment Protection Act 1986. So, if we are using this genetically modified organism, it should be used inside the laboratories or inside the laboratory area that is specifically notified under the Environment Protection Act 1986. Any person operating or using genetically modified organisms for scale up or pilot operation shall have obtained permission from GEAC. So I already mentioned that any person who is personally using it for any particular operation or any invention must have obtained a permission from Genetic Engineering Appraisal Committee. Experiments for the purpose of education involving genetically modified organism can be undertaken with the oversight of IBSCS, that is, any educational purpose involving the use of genetically modified organism should be undertaken by the supervision of the Institutional Biosafety Committee. So, if a particular institution is using any genetically modified organism, there should be one Institutional Biosafety Committee and the permission from the IBSC. Then deliberate or unintentional release of genetically modified organisms are not allowed. So it is initially said that no person has the right to import or export or transport or manufacture, process, use or sell the genetically modified organism. So deliberate or unintentional release of genetically modified organism is completely prohibited. It is not allowed. Then final one, production in which genetically modified organisms are generated or used shall not be commenced except with the approval of GEAC. Approval shall be for a period of 4 years and first instant renewable for 2 years at a time. It means if any of the process that will generate a genetically modified organism or it includes the use of genetically modified organism should be with the approval of GEAC, that is the Genetic Engineering Appraisal Committee, and the approval is only for 4 years, which have to be renewed in every 2 years. So the Genetic Engineering Appraisal Committee or GEAC is regulatory in function. So without their approval, the dealing with genetically modified organism is not possible. So the Genetic Engineering Appraisal Committee have the powers to revoke approval. It means they can cancel the approval in case any information on harmful effect of GMOs. It means if they got a particular information about a particularly genetically modified organism that we are using in the lab, and they have already given the permission to work on that, but on getting information about the harmful effects of that particular organism, they can revoke or they can cancel the approval. And then second case is GMOs cause such a damage to the environment as could not be envisaged when approval was given. Okay, so they come to know that the particular GMO has severe harmful effect, or it can cause severe harmful effect to the environment that were not known when they were giving the approval. So on realizing that, they can cancel the approval. Then third instance is non-compliance of any conditions stipulated by the GEAC. If we are not following the conditions that we agreed with GEAC, they can also revoke the approval. So these are the three instances. So and that the GEAC can revoke the approval. So it means that at any time they have the power to revoke the approval. So far we have seen how genetically modified organisms are protected under the 1989 rule, and what are the approvals and prohibitions, and which are the regulatory and monitoring and advisory authorities over genetically modified organism. Let us conclude this video with the major rules that is aimed to protect or that deals with the genetically modified organisms and their products. The first rule, that is the rules for manufacture, use, import, export and storage of hazardous microorganism, genetically engineered organism or cells 1989, that is issued under Environment Protection Act, that is the rule 1989. It is implemented by the Ministry of Environment, Forest and Climate Change. It covers entire spectrum of activities including genetically modified organism and products, and thereof it includes the sale, storage, exportation, importation, production, manufacturing, packaging, etc. And the foodstuffs have been moved out of the purview of the rule 1989 recently. So the rest of them are included here. So that is all, a brief description about this rule 1989. The next we will go through a brief description about the plant quarantine order 2003 or the plant quarantine regulation for import into India 2003. It is also implemented by Ministry of Agriculture and Farmers Welfare. It covers regulation of import of germplasm or genetically modified organisms or transgenic plant material for research purpose. So, as we all know that only these transgenic materials or germplasms can be imported into our country only for research purpose, not for other purpose. So, these particular rule specifies some regulations for the import of these particular germplasms or transgenic materials into our country. And the third rule is the Biodiversity Act 2002, implemented by National Biodiversity Authority. It regulates the use of biological resources including genes used for improving crops and livestock throughout genetic intervention. And the fourth one is the Food Safety and Standard Act 2006, implemented by Food Safety and Standard Authority of India. It regulates manufacture, storage, distribution, sale and import of food which include genetically modified food organisms. Okay, which include the genetically modified food. So initially it was involved in or included in the rules 1989. Later it was separated as a specific rule. So we have discussed about Indian Patent Act 1970, its new amendments and the protection of new genetically modified organisms, and what all are the laws dealing with genetically modified organisms. So let us conclude with a brief note. To comply with the World Trade Organization and the TRIPS Agreement, India amended the Patent Act 1970 with effect from January 2005. The Indian Patent Act has now a specific provision in regard to patenting of microorganisms and microbiological processes. It is now possible to get a patent for a microbiological process and also a product emanating from such process. So initially, any organisms, whether it is genetically modified or not, it is considered to be non-patentable matter, but now this genetically modified organism means the microorganism, genetically modified microorganism and the microbiological processes are patentable. Okay, the most vital distinction between the legal practice of India and developed countries is that India does not allow patenting of microorganisms which already exist in nature, as the same is considered to be a discovery as per the provision of the Section 3 of Patent Act 1970 and therefore not patentable. But genetically modified version of the same organism that result in enhancement of its own efficacies are patentable. So initially I have the previous video I have explained that a known process with an increased efficacy is patentable. So like that, the naturally occurring microorganism is not patentable, but the genetically modified version of that organism that has more efficiency is patentable. Okay, so that is all about Indian Patent Act 1970 and the protection of new genetically modified organism. Hope it's clear. Thank you.